दे दिया उसने। ये रास्ते में मैंने
Good afternoon, ladies and gentlemen. I'll request Maqsood sir to make the event live. Is the event live, Maqsood sir?
Yes, no, right now live.
Yeah, thank you. Well, everybody, welcome to Amity University, a research and innovation-driven university. Today, this is the Valedictory ceremony hosted by Amity Law School, Noida at Amity University, Uttar Pradesh, in collaboration with School of Business and Law, Edith Cowan University, Western Australia. It is said that the Indian jurisprudence has witnessed intense legal practice and comparative law legal scholarship. Its tremendous growth in the last few years has given significant global developments, transnational governance, and complex economic interdependence, which also talks about Atmanirbhar Bharat, and that is aided by the development of the new communication and information technology. Nevertheless, comparative law, therefore, as old as the law itself, has become of tremendous significance for the growth of the modern legal societies. Well, as Mahatma Gandhi says, truth will never damage a cause that is just, and it is truth that will prevail because Satyameva Jayate, it is truth that triumphs, not the falsehood. And Satya, the truth, is the dharma, the righteousness. And wherever there is dharma, there is victory. Yato dharmas, tato jaya is the motto of the Honorable Supreme Court of India. Welcome, everybody. On behalf of our Honorable Founder President, Dr. Ashok K. Chauhan, I welcome you all to the valedictory ceremony. Without any further ado, I would request my colleague Rupendra sir to play the Saraswati Vandana video, and with that we invoke the blessings of the goddess, and with that we would also welcome our guests for the day. Thank you so much, sir. Well, we've begun the ceremony with an invocation that is dedicated to the light in our lives. Now, as a tradition at Amity, let's welcome all our guests with Tulsi saplings. I'll request my colleague Rupendra sir to play the presentation of the Tulsi saplings video. And with that, we welcome all our guests on this luminous dais. At Amity, modernity blends with tradition, and presenting a Tulsi sapling showcases a green initiative at the campus. Amity University today is 12 universities in India with 16 global campuses and 28 schools and preschools under the blessings and guidance of our Honorable Founder President, Dr. Ashok K. Chauhan. We welcome all our eminent guests for the day, and here we present the saplings for guests for the valedictory ceremony. Being presented to Mr. N. Venkatram, Additional Solicitor General. Great thanks, respected citizens of the association. I'm so touched with your virtual presence. We now present the sampling to Ms. Najat Abushan, who is investigating judge, military board based in Lebanon, this conference. We are always Honorable Chancellor Dr. Atul Chauhan, sir, who believes that together we can change the world. And let us all be those agents of change. Let us all try to make a difference in the life of the people. And in the service now, to our Honorable Founder President, Dr. Ashok K. Chauhan, sir, who believes that every Indian should be an asset to the society and to the world, and that he's committed to creating a world where we are creating the best citizens. Thank you so much, Thank you so much. Well, ladies and gentlemen, post India's G20 presidency, we are now a nation which is more inclusive, ambitious, action oriented, and decisive. We have together tried to make it a healing, harmonious, and hopeful world. And together we have worked together to shape a new paradigm of human centric globalization as had been envisioned by Honorable Prime Minister Shri Narendra Modi ji. Without any further ado, I will now request Professor Dr. Aditya Tomar, Conference Chairperson, Additional Director and Joint HOI, Amity Law School, Noida, to present his address. Professor Dr. Aditya Tomar.
Very good afternoon, everyone. I welcome one and all to the 5th International Conference on the Comparative Law hosted by the Amity Law School, Noida, in collaboration with School of Business and Law, Valedictory University, Western Australia. On behalf of the brimming spirit and the zeal of organizing committee, I warmly welcome our eminent guest for today, our special guest of honor, Honorable Sadak Jemos, Solicitor General of Republic of Kenya. We are honored by your presence, sir, here today and eager to hear your insight. Most welcome, sir. I welcome Mr. Alfred Tua Yebo, Deputy Attorney General and Minister for the Justice, Ghana, who heartily agreed to present his address today. Thank you, Honorable Sir. My hearty welcome to Honorable Ms. Nazat Abu Chakra, Investigative Judge, Military Court, Beirut, Lebanon, who took out time despite a busy schedule to address the conference. Many thanks, respected madam. In the spirit of my most humble gratitude, I warmly welcome to Mr. Rajesh Ramlal SC, Deputy Solicitor General of Mauritius. Welcome to ICCL conference, sir. We are honored by your presence and look forward to the learning from your experiences, sir. My most humble welcome to our guest of honor, Mr. N. Venkatraman, Additional Solicitor General of India. We are grateful for your presence here today, sir. We are eager to hear you. My most heartfelt thanks to our Honorable Founder President, Dr. Ashok K. Chauhan, and Honorable Chancellor, Dr. Atul Chauhan, with whose blessings, love, and support we continue to make all the differences in the world by instilling in us and valued of hard work, inspiration, social outreach, so that we can create a just society for the present and future generations. I'm also deeply honored and humbled by the trust endowed upon by the great leader of higher education, Honorable Vice Chancellor, Professor Dr. Balvinder Shukla, who has always motivated us to do something bigger in the innovative way every time. My heartfelt thanks to Honorable Chairman Dr. D.K. Bandyopadhyay, who has been a great leader of higher education and whose motivation Amity Law School Noida is growing each day on the global canvas. My most humble welcome to our dear friend Dr. Joshua and Austin, Associate Dean, School of Law and Business, Edith Cowan University, Western Australia, and Conference Chairperson, Australia, who has been our side in every academic endeavor that we do. Thank you, Dr. Joshua. All the delegates to the conference, faculty members, judges, and students. And thank you all in attendance in the valedictory ceremony, both in online and offline mode, who have joined us in the campus. Laws are evolved and developed in many ways. Comparing the laws of different nations or even cultures provide for a unique way of develop law in better manner. Comparative law is one such method which describes the comparisons between the different legal systems. Now, in the valedictory ceremony, we are fortunate to have the esteemed guests from the different parts of the globe with different cultures, climate, business practices, and law, who will lighten us with their valuable word of wisdom. Now, without taking much of your time, I extend warm welcome once again to all the esteemed guests online and offline to this valedictory ceremony. Thank you. Thank you very much.
Thank you, Professor Dr. Aditya Tomar, Conference Chairperson, ICCL 2024. Well, that reminds me that law is not law if it violates the principles of eternal justice, and many such themes were discussed during the two-day conference. So without any further ado, ladies and gentlemen, I would now invite Professor Dr. D.K. Bandyopadhyay, Chairman, Amity Law Schools and Chief Advisor to our Honorable Founder President's Office of the Amity Group, Professor Dr. D.K. Bandyopadhyay, sir, for his address. Chairman, sir. Sir, you are not audible. Chairman, sir, you're on mute. Yeah.
Yeah. It is indeed a great pleasure and privilege for me to be present here in welcoming the Attorney Generals of different countries, the Deputy and then Solicitor General of different countries. What else can be the best way of making the valedictory session? So there is a proverb. I started with the proverb, well begin is half done. Now I am also using the other proverb. The proverb says that all end that ends well. All good that ends well. All good that ends well. Now this is a great ending that will be taking place. Sirs, on behalf of the Amity Universe, on behalf of our Honorable Founder President, Dr. Ashok K. Chauhan, on behalf of our Chancellor, Dr. Utul Chauhan, who is actually spearheading education as a movement in the country. Education as a facilitation process for making the nation to be more strong, and also making the planet to become a livable planet. And they are relentlessly working for their mission, and we are part of this mission. And they have given us the platform for having this type of narratives development for the benefit of the society and benefit of the mankind. Sir, Honorable Sadrik G. Mose, Solicitor General of the Republic of Kenya, Mr. Alfred Tuabwa, Deputy Attorney General of Ministry of Justice, Ghana, Honorable Ms. Najat Abu Cherka, Investigatory Judge, Military Court, Beirut. And what a great, great place, Beirut. And Mr. Rajesh Ramlal, Deputy Solicitor General of Mauritius. And then our own Mr. N. Venkataraman, Additional Solicitor General of India. Sir, really, your presence had made our conference a great, impacting factor of the success of this conference. And we all the time look forward for such type of great people across the globe to come us, to tell us about their country, so that we learn from each other. So we had a Nobel laureate known as Rabindranath Tagore. Rabindranath Tagore all the time says that India is such a country where many people come, many people contribute, many people then learn out of the country. They give something to us, they take something from us. And this is the nobleness of our country. And with this nobleness, India is progressing and progressing very fast with all the cooperation, collaborations, and association with the people like you. And we shall be looking forward in future for having such type of interactions, maybe in another platform, so that our learning process become more and more stronger, our collaborative process becomes more and more stronger. Now, I congratulate Dr. Aditya Tomar and of course, Joshua. Joshua, he is now located in Australia. He is listening to our valedictory session. Both of them are working relentlessly to make this comparative law of different facets of our justice delivery system, so that we learn from each other. Also make a different types of, listening ourselves. So with these few words, may I request Dr. Sumitra, please carry on with this spirit. And I only tell to my distinguished guests, sir, we are more than delighted, more than happy of having you over here, and also, making it a point that Amity is a place which are totally different from other places. Amity is a place where all the best brains, they try to converge. And with this message, I'd like to conclude my speech, and I will be failing in my duties if I do not appreciate the organizing committee consisting of faculty members like Rupender Singh, Sumitra Singh, and our student volunteers who work longer duration in terms of planning and executing this conference. A great lessons that has been drawn out of it. We are going to publish a book out of this learning, and we'll be able to showcase that book in the different parts of the globe. That here one school, they're doing so much of work in learning from other countries and trying to influence the necessary changes or necessary examples in the justice delivery system of India. So thank you very much. Thank you once again.
Thank you, Chairman, sir, for those beautiful words and setting the ball rolling, actually, for the conference's
and from Sumitra, from
Yes,
the
sir.
honorable guest, I will seek permission because I have come out on some emergency work. So I will request my all guests who have been invited through virtual platform, just to apologize me because I will not be able to see them. So it will be my loss rather than their loss. So carry on, Sumitra, carry on, please.
Yeah, thank you, sir. And also we are live on YouTube. So I'll request you, in case you're not there in the meeting, you can join us on YouTube as well. Thank you, Chairman, sir, for your blessings and your words of motivation. Well, everybody, on this panel today of all the luminous legal minds at the valedictory ceremony of International Conference on Comparative Law 2024, hosted by Amity Law School, Noida, together with Edith Cohen, School of Business and Law, Western Australia. We have one person amongst us who reminds me of none other than His Lordship Willie Mutunga, former Chief Justice of the Kenyan Supreme Court, who once said, he quoted rather, about the Chinese philosopher Lao Tzu, that the journey of the 1,000 miles begins with a single step. And he said that I can't even say that we've achieved the first step. Rather, the Constitution itself is a great leap forward. With that note of Honorable Justice Willie Mutunga, I would now invite Honorable Shadrach J. Mose, Solicitor General of Republic of Kenya, our guest of honor, to present his address. Honorable Mr. Shadrach.
Thank you, Sumita Singh, and all the distinguished guests for giving me an opportunity in this afternoon to address this distinguished forum. Distinguished guests, ladies and gentlemen, good afternoon. Receive very warm and heartfelt greetings from Kenya. First and foremost, allow me to most sincerely thank you for according me the privilege of joining and addressing you at this 5th Annual International Conference on Comparative Law. The theme of the conference is timely due to increased globalization in the socio, economic, as well as political landscape. Today, being the second and final day of the conference, I am sure you have had occasion to not only interact with various articles and presentations on the conference thematic areas, but also engaged in insightful discussions that have no doubt enriched the discourse on comparative law. I wish to add my voice to this great conference team as I briefly share my thoughts on comparative constitutional law. Esteemed colleagues, comparative constitutional law provides an opportunity to study normative constitutionalism for purposes of comparison, as well as the identification of similarities and variations in constitutional interpretation in light of varied socio-economic and political backgrounds. The place of comparative constitutional law cannot be overstated. It provides a basis. One, a comparative intellectual understanding of other legal systems and jurisprudences. The study of political power in different contexts. The use of comparative constitutional law in judicial decision-making and adoption of best practices. Esteemed colleagues, allow me to share the Kenyan constitutional experience. Kenya's constitution 2010 can be described as both aspirational and transformative. It echoes elements both in the civil law and the common law systems, although the system of law is fundamentally common law. The Constitution of Kenya 2010 was the culmination of diligent historical efforts and is often described as one of the greatest achievements in governance since Kenya's independence in the year 1963. Kenya's constitutional reforms enjoyed massive support for a great many reasons, including the following. One, it created a decentralized system of government characterized by two levels of government, that is the national government and the county government. It sought to restructure and reform core institutions of governance, notably the executive, the legislature, and the judiciary, under the doctrine of separation of powers. It sought to protect and promote the rights of its citizens in a more intricate manner through the introduction of an extensive, elaborate, and reparable Bill of Rights, as well as the protection and promotion of socio-economic and political rights of Kenyans. Comparative constitutional law accorded Kenya an opportunity to adopt structure, approach, and principles of provincial and local government from South Africa. This is exemplified in the constitutional provisions on devolution, which lie at the heart of the Constitution of Kenya 2010 and have provided a means of addressing past injustices. I would like to highlight some of the features of the Constitution of Kenya 2010, which exemplifies its aspirational as well as transformative attributes. Insofar as it makes the explicit space for the possibility of a future, the Constitution of Kenya is aspirational. The future is presented as being open and is identified with a range of aspirations and broad objectives such as peace, justice, and equality. This embodies a diverse understanding and interpretation over prolonged periods of time. What this does is that it ensures that the Constitution stays alive and does not lose its purpose. This is exemplified in Article 10 of our Constitution, which provides for national values and principles of governance. The provisions in the Bill of Rights, notably Article 43 on economic and social rights, as well as Chapter 5 on land and environment, echo the aspirations of the Kenyan people and the duty by the state to ensure the dignity of all persons through progressive realization of economic and social rights. The Constitution of Kenya 2010 is transformative insofar as it articulates a guess to introduce changes to the system of governance. It did introduce a decentralized system of governance with 2 levels of governance, national and county government. It also introduced checks and balances, thus ensuring that there is transparency in the exercise of power. This has also been key in ensuring there is reduced marginalization due to political differences. Esteemed colleagues, we must appreciate that the existence of a written constitution is not an implicit guarantee of constitutionalism. Constitutionalism relies a great deal on political goodwill to uphold and respect both the letter and the spirit of the Constitution by all arms of government, given the socio-economic and political circumstances of a country. The choice of India as the host of this 5th annual International Conference on Comparative Law accords us all an opportunity to join our dear brothers and sisters in celebrating the just concluded Republic Day marked on 26th January this year, and bear witness to the important role comparative law played in the architecture of India's constitution. Most of us know that India's constitution-making process was the result of a deliberate, careful comparison of constitutions of different countries, notably the US, Ireland, Canada, France, Australia, and South Africa, among many others. Comparative constitutional law continues to evolve against the backdrop of rapid cultural change and the technological acceleration. Countries continue to face similar governance problems, even with different cultural, political, religious, legal histories. Similarities and differences provide a basis for continued comparability. Esteemed colleagues, as we celebrate and share experiences from the study of comparative constitutional law and its outcomes, I encourage us to be guided by the words of Abraham Lincoln. He has a right to criticize, who has a heart to help. As I conclude, I wish to reiterate that comparative constitutional law accords us an opportunity to seek excellency and promote constitutionalism and good governance aimed at promoting the common good at the national and the international level. Once again, I extend my sincere gratitude to the organizers of this conference for inviting me to be part of the meeting today. Ladies and gentlemen, what we learn from each other across the globe is a clear demonstration that we are there for each other and we should remain there for each other and ensure that apart from even as I have stated, apart from the constitution, the written constitution, we must ensure that constitutionalism in its true and actual sense actually exists and thrives. Ladies and gentlemen, thank you for your time. I wish you all a successful day. Thank you, and God bless all of you.
Thank you so much, Honorable Mr. Shadrach Jemos. Let's have a round of applause for sir. Beautiful address, sir. And very beautiful words said so by you, sir, that we are there for each other. And that is what today the world is looking after. And, we've always believed, India as a country has always believed in what we say, that world is but a global village. We call it as Vasudhaiva Kutumbakam. Thank you so much, Honorable Mr. Shadrach Jemos, Solicitor General of Republic of Kenya. Shortly, sir, we will also be presenting you a citation of honor. So I'll request you to kindly stay back. Thank you so much, sir, for your address. Ladies and gentlemen, we have with us another distinguished guest of honor, none other than Mr. Alfred Tua Yeboah, who is Deputy Attorney General and Minister for Justice at Ghana. And before I invite Honorable Minister, Deputy Minister for Justice at Ghana, I would like to quote Chief Justice Maraga, who once said that the greatness of any nation lies in its fidelity to the Constitution and adherence to the rule of law, and above all is the respect to God. And that is where India and Africa also converge. So it is with great respect, delight, and honor that I now invite Honorable Mr. Alfred Tua Yeboah, Deputy Attorney General and Honorable Minister for Justice at Ghana. Mr. Alfred.
Thank you very much. Let me also indicate my gladness for the opportunity granted me to address this August conference. Chair for the conference, distinguished guests, ladies and gentlemen, I bring you warm greetings from the Republic of Ghana. And for those who don't know where Ghana is located, Ghana is in West Africa, along the Gulf of Guinea. It's a country of about 34.5 million people. In order to appreciate the constitutional architecture of Ghana, I would like to take you back into history. For that matter, you can better appreciate how come that we have a constitution which is now so resilient and has been able to stand the test of time. Ghana attained its independence in 1957. And at the time of independence, adopted the British system of governance, where our first president, Dr. Kwame Nkrumah, under the 1957 Constitution, was the prime minister, but the Queen remained the ceremonial head. In 1960, Ghana adopted its first Republican Constitution under the presidency of Kwame Nkrumah. For that matter, for the first time, the power of the British monarch to control the affairs of the people of Ghana was taken away. Unfortunately, however, Ghana has experienced various military interventions. In 1966, Ghana's first Republican Constitution of 1960 was abrogated through a military intervention. In 1969, Ghana had its second Republican Constitution. Under the second Republican Constitution, Ghana adopted the British system of government, the Westminster type, where we had the Prime Minister and the ceremonial president. Unfortunately, however, once again, this constitution was also toppled in 1972 through another military encounter. The military in Ghana took affairs of the Republic from 72 to 1979, when we had another military intervention. Fortunately, in the 79 military intervention, within the same year, elections were held under a new constitution, under the 1979 Republican Constitution. This constitution also had provisions relating to how assembly governance were to be conducted. And under that constitution, it was purely presidential system of government. So we had a president without a prime minister. 2 years after 79, 1981, there was also another military intervention, and the constitution was once again abrogated. And so from 1981 until 1992, Ghana was under military rule. However, in 1992, Ghanaians resolved that enough was enough and decided to come together under the presidency of the late Jerry John Rawlings to give itself a new constitution. And this constitution is what I'm saying is so resilient and has stood the test of time. This discussion I'm going to have is basically on the 1992 Constitution of the Republic of Ghana. Under this constitution, we have an executive president. We are operating under the presidential system, where we have a president together with his cabinet, together with his ministers. There is actually a separation of powers. The three arms of government are in place: the executive, judiciary, and then the legislature. But in Ghana, there's no watertight separation of powers. This is simply because majority of ministers who are to be appointed by the president are to be members of parliament. And so you can see a fusion between the executive and the legislature when it comes to separation of powers. Ghana, as a democratic state, in its constitution, has elaborate provisions on civil liberties. Ghana, in its constitution, in chapter 5, has dedicated the whole chapter to civil liberties. First generation rights have been enshrined in our constitution, as well as other rights. In our constitution, educational rights, and what have you. One of the key tenets of our constitution is the freedom of the media. In Ghana, per our constitution, a person does not have to get a license before establishing a media house. That's a constitutional provision. In view of this media landscape, as we speak now, there are over 700 television and radio stations in a small country of Ghana, of not more than 34.5 million people, that people have the right to express their opinions. Until the year 2000, there was this colonial law in our statute books given to us by Britain, which criminalized free speech. However, with the advent of our constitution, that law has been repealed, and now it is not a criminal offense to offer any kind of speech that you may want to offer in Ghana. Ghana's constitution, because it recognizes the liberties of others, has given people the right to ventilate their opinion or any other thing that they think is not in their interest. So if a person's rights are infringed upon, that person has the right to go to the high court in Ghana to ventilate his concerns. Or the person has also the right to go to the Supreme Court for the interpretative and enforcement jurisdiction of the Supreme Court to be activated. There is also established in the Constitution a Commission on Human Rights and Administrative Justice, which is principally responsible for the issues of human rights in Ghana. Ghana's parliament has legislative power subject to provisions of the Constitution. And so, under Ghana's present Constitution, it is the duty of parliament to make laws. However, such laws emanate from the executive. And that if the executive introduces any bill in parliament, it is the duty of parliament to debate that bill and come to a conclusion on the matter. But there is another provision that is so interesting. In our constitution, a private member also has the right to initiate bills in parliament. But this process is a bit laborious. Laborious because the provision of the constitution are to the effect that if you're a private member and you want to introduce any private member's bill, that bill should not have the potential of incurring debts to the public, or she should not have any charge on the consolidated fund. And because of this provision, many people were not interested in venturing into going to parliament private members' bills as MPs. Thankfully, for the last 5 years, a lot of laws in Ghana have gone through parliament through private members' bill. I think it's something that Ghana is very proud of. Now, if we move to the electoral process in Ghana, Ghana has a very robust electoral commission with its powers actually given under the Constitution. And the electoral commission in Ghana is chaired by the chairperson of the electoral commission and other commissioners, who are 6. These commissioners are appointed by the president on the advice of the Council of State. However, once they are appointed as commissioners, they are not subject to the dictates of the executive or the judiciary, so the legislature, apart from the judiciary, who can make judgments or rulings regarding their activities. Now, Ghana's constitution, because it seeks to curb military interventions, has given time limits to presidents. For that matter, a person can be a president for 4 years, subject to renewal once. And this provision has been strictly adhered to. On the judiciary, Ghana has a judiciary which is headed by the Chief Justice of the Republic, and the Chief Justice is appointed by the President in consultation with the Council of State, subject to the approval of Parliament. And once the Chief Justice is appointed, together with the other judges, they remain independent and are not subject to the control of the executive, and for that matter, any other person apart from the laws of the Republic. Ghana judiciary since 1992 has given far-reaching decisions seeking to enforce their power of judicial review. Many actions of various governments have been struck down as unconstitutional by the Supreme Court in Ghana. The latest being the government I'm part of, where during the time of COVID, the president, under an act of parliament, sought to impose limitations on the rights of people in Ghana. Individuals decided to test the constitutionality of the power of the president to impose limitations having regard to the constitutional provisions. And it may interest to know that the Supreme Court of Ghana struck down that legislation that was unconstitutional. There have been instances where people also sought to say without licensing, you could not operate a media house. It went to the Supreme Court, and the Supreme Court said, nobody is expected to acquire a license before he set up a media house. So when it comes to judicial review and constitutionalism, rule of law, Ghana's judiciary is doing so well. And the judiciary in Ghana has the lower courts and the superior courts. The lower courts are made up of the district courts and the circuit courts, and the superior courts are made up of the High Court, Court of Appeal, and the Supreme Court. The Supreme Court has jurisdiction to interpret the Constitution, have jurisdiction to look at the issues relating to presidential election disputes. They also have jurisdiction related to criminal and civil proceedings or matters. And when it comes to parliamentary electoral disputes in Ghana, it is the duty of the High Court to look at same, and the appellate level lies to the Court of Appeal. In our Constitution, there are various democratic institutions set up to ensure that we go by the tenets of rule of law. One of them is the Commission on Human Rights and Administrative Justice, the National Media Commission, National Development Planning Commission, National Commission on Civil Education, the Lands Commission, and a host of others. But we must also remember that Ghana is a country that cherishes chieftaincy. And for that matter, chieftaincy has been given a space in our Constitution, because when it comes to governance at the local level, chieftaincy plays a very key role. Ghana, as a state, believes in international laws and rules, and we believe in also international law and diplomacy. But when it comes to our foreign relations, per our Constitution, the interest of Ghana is the first thing that we look at. Of course, for international law and diplomacy. How do we amend our Constitution? Our Constitution has two main clauses, or two main amendment provisions. We have the entrenched provisions and non-entrenched provisions. When it comes to the non-entrenched provisions, very simple to amend, but the entrenched ones, very robust. You have to go through Parliament to have at least 75% of members of Parliament agreeing, go to a referendum where at least 70% of voters must agree to that amendment, and to ensure that the Constitution it is also not abrogated along the line. Some provisions of the Constitution, at least the major ones, are entrenched provisions. The last thing, because of time, I want to talk about is this provision of the Constitution so interesting, what we call the indemnity clauses. Now, because of our history as a people, in the current Constitution, we sought to give indemnity to all those who took part in the previous military regimes in Ghana, so that they could not be called upon to account, because doing so may actually destabilize our situation. So that's a provision that has been embedded in our Constitution, to also just to make sure that the past is covered, but to ensure that people's pain was not carried forward. We set up a National Reconciliation Commission to heal wounds. And with the indemnity clauses, I dare say that Ghana has enjoyed peaceful democracy from 1992 up to today. Ghana is a model democratic state. Ghana is a state that's ready and willing to join the elite when it comes to democracy. We are also receptive to international norms and our international relations because we belong to lots of international organizations, and we make sure that we go by the treaties that we engage in or we enter into. With this, I would like to conclude by thanking the organizer of this program for giving this opportunity to shed light on Ghana's constitutional architecture. Thank you very much.
Thank you so much, Honorable Mr. Alfred Yeboah. Let's all have a round of applause for Mr. Alfred. Thank you so much, sir. And with your address, yes, our students and all of us have gained a lot of insight into the Constitution of Ghana, and also we've learned about the judicial system there. Thank you so much, sir, for your wonderful address. Well, ladies and gentlemen, moving on further, let us now try to get the discourse on Lebanon. What is the Lebanese discourse? But before I invite our dear respected Madam Najat Abu Chakra up here, I would like to quote in something that gives us a Lebanese perspective, at least the way of life of the people. Well, I remember Ilya Abu Mahdi, who said once that you are not the clothes you wear, and you are not the names that you bear. You are not the countries where you grew up, but you are what you do. At the same time, we have Lucien Bourgelet, who says that the freedom of expression is actually a way for the people to know themselves much better and to understand themselves much better, because without it, you become a stranger to yourself. And that also gives us the in thing about how a person should live with dignity and honor. Having said so, let us now delve into the Lebanese discourse. And to that effect, I will now request our guest of honor, Honorable Ms. Najat Abu Chakra, Investigative Judge, Military Court, Beirut, Lebanon, to present her address. Honorable Ms. Najat, over to you, ma'am.
Thank you so much, Dr. Zing, and good morning to you all, because now it's 11:53 a.m. in Lebanon. I hope you're all doing well. I'm so happy and so honored to be with you again for the third time. I'm so happy to see you, Dr. Joshua, Dr. Zing, and Dr. Tomer. And I'm so happy also to see our guest from Kenya and from Ghana. I consider myself to be an Amitian now, so I don't feel like stranger. I feel like I'm between my friends. I chose to talk today about human rights in the Lebanese constitution and the Lebanese penal laws, and I would try to share my screen maybe to show you the PowerPoint. I hope I will succeed in that. Can you see my screen?
No, ma'am. Ma'am, there is a screen share option there.
Yes, I have Adam تجي ماما بتساعدني.
Maqsood sir, can you help, ma'am?
Okay, there's the share button.
Yeah.
Okay, and maybe I'll try again now. Can you see it?
Ma'am, it's showing that something is being shared. Yeah.
Yes.
Yes.
Okay.
We can see your desktop. We can see your desktop, yes.
Okay, so this is my topic that I will be talking about today, and you can find my email if somebody would like to contact me. This is the link where you can find the Lebanese constitution in English version if somebody would like to read it as well. So the Lebanese constitution, its last version of 1990 that was issued after the civil war, stipulates a number of human rights in different articles as follows, and I will only be reading the content of the articles that interest some of us as specialists in criminal law. It's not moving. I don't know what's happening. Just a second. Okay. So in Article 7, the Lebanese constitution stipulates the equality before the law, and it lists that all Lebanese shall be equal before the law. They shall equally enjoy civil and political rights and shall equally be bound by public obligations and duties without any distinction. In Article 8, the right in individual liberty and the principle of legality of crime and punishment. Individual liberty is guaranteed by law. No one may be arrested, imprisoned, or kept in custody except according to the provisions of the law. No offense may be established or penalty imposed except by law. Article 9, the right of conscience. Article 10, the right in education. Article 12, the right to hold public office. Article 13, the right to hold, the right in free speech, where it stipulates the freedom to express one's opinion orally or in writing, the freedom of the press, the freedom of assembly, and the freedom of association shall be guaranteed within the limits established by law. Article 14, the sanctity of the place of residence. Article 15, the rights of ownerships. Well, we see that the Lebanese constitution does not stipulate litigation rights that guarantee a fair prosecution for the suspect and a fair trial for the defendant. For example, it does not stipulate the equality before the judiciary, the right of defense, the right to remain silent, the right to legal assistance, the principle of the presumption of innocence, the right to appeal the arrest decision, the right of not being prosecuted twice. The Lebanese constitution does not stipulate one of the most important economic rights, the right to work. It does not stipulate as well one of the most important political rights, the right of self-determination. But the guarantees of a penal or criminal fair trial were stipulated in many laws, including the Code of Criminal Procedures and Penal Code. For example, the Code of Criminal Procedure stipulates the right to remain silent in Articles 47, 77, 180, and 253. The right to legal assistance in Articles 47, 76, and 251. The right to appeal the arrest decision in Article 107. The Penal Code stipulates the right of not being prosecuted twice in Article 182. And the preamble of the Lebanese constitution listed in paragraph B that Lebanon is also a founding and active member of the United Nations organization and abides by its covenants and by the Universal Declaration of Human Rights. The government shall embody these principles in all fields and areas without exception. The Constitutional Council in Lebanon ruled that the principles listed in the preamble of the Constitution are considered to be an integral part of it and have constitutional value, just like the provisions of the Constitution themselves, which means that the right to work and the right of self-determination are considered to be fundamental rights by Lebanon as a state, by its government that should respect these rights in every law or decree issued, and by its judiciary that should respect and apply the international convention that prevail national laws as listed in the Article 2 in the Civil Procedure Code, which is considered to be the general law for all procedure laws. The Constitutional Council in Lebanon ruled as well that the equality before the judiciary is a constitutional principle and is derived from the principle of equality before the law. And the Constitutional Council in Lebanon ruled that the right of defense has a constitutional value, even if not listed in the Constitution. So to conclude, I will say that Lebanon as a state, its government and its judiciary respect all international conventions that guarantee human rights, even if some of these rights are not listed in the Constitution or in ordinary laws. And thank you so much for listening.
Thank you so much, Najat ma'am. Let's have a round of applause for our honorable and dear Ms. Najat Abu Chakra ma'am. A wonderful discourse on the Lebanese constitution. And ma'am, when you say that you are an Amity, and it fills my heart with pleasure and delight. It says, we here at Amity say that, once an Amitian is always an Amitian. Thank you so much, ma'am, for being an Amitian. And today,
I remember this sentence very well from my first participation, and I'm so happy to listen to what Elia Abu Madi said and what Abu Jaili said. This was very excellent to listen, really, and to listen from you. Thank you so much.
Yeah, ma'am, that is how the Indian and the Lebanese sensibilities match. And thank you, ma'am. Now, in fact, right from we met first online, I think you've become a part of the Amity family. Thank you so much, ma'am.
Thank you so much. I'm honored.
Thank you. Well, ladies and gentlemen, going ahead in the schedule, I remember Nelson Mandela, who said once that it is not our diversity that divides us, and it is not your ethnicity which divides you, neither the religion or the culture that divides us. Since we've achieved our freedom, there can only be one division amongst us between those who cherish democracy and those who do not cherish democracy. What more can be the further discourse? And Mauritius, let's try to find out from none other than our guest of honor, Mr. Rajesh Ramlal, SC, who is Deputy Solicitor General of Mauritius. Over to you, Honorable Mr. Rajesh Ramlal from Mauritius.
Thank you. Thank you, Dr. Sumitra, for this introduction. It's incredibly an honor and pleasure to be addressing you from Mauritius. I see a number of familiar faces. I recently met last week in Delhi, and it's good to find a number of our good friends today on this Zoom conference in hybrid mode. So, well, let us start with the protocol. The judges and former judges today, the conference director, Professor D.K. Bandyopadhyay, the chairman of Amity Law Schools, the patron, Mr. Dr. Atul Chauhan, the conference chairs, Professor Aditya Tomar, the Associate Professor, Dr. Joshua Aston from Edith Cowan University, Australia, the conference convener, the sponsorship committee, and other friends and colleagues, distinguished colleagues in attendance on this call. So one interesting thing is this call is made possible by the progress that technology has taken us to, and always thankful to technological progress because it gives us a platform, whether we're in Lebanon or Kenya or Ghana, all from Mauritius, were able to share that common platform this afternoon. And Lebanon, it's in the morning. One of the biggest challenges is to get people across the globe with different time zones to meet and challenging those time zones there. So it is my pleasure to address you from Mauritius on a very interesting topic, which I understand was one of the themes of the conference, Comparative, IPR, Technology Law, and Emerging Legal Domains. So I'll address you on the issue of artificial intelligence, technology law, and its impact on access to justice from the perspective of a small country. So, well, Mauritius is an island. It is a small state. It is in Africa. So, although politically we are in Africa, it's right in the middle of the Indian Ocean. Right. So I refer to a number of constitutional law concepts as I develop the idea of access to justice. Now, I am not a scientist, but a lawyer by profession. Therefore, my address will mostly focus on the legal aspects of access to justice and artificial intelligence. More particularly, I wish to provide another perspective on this ongoing debate about artificial intelligence and whether it helps access to justice as a constitutional concept, part of the rule of law. That perspective comes from a small state like Mauritius, an island of about 1.3 million people, right, as I mentioned, in the middle of the Indian Ocean, which many people most idyllically know as a tourist destination. So first, I shall highlight the access to justice issues with which a small state like Mauritius currently faces. Second, I shall set out the promises that AI, as we generally call it, holds and how it could theoretically help a small state like Mauritius improve its access to justice. And third, I will set out some challenges which a small state may face when it comes to deploying or using AI tools to its access to justice. More particularly, my concern is for all the promises that AI holds, AI can also, if not deployed properly, further exacerbate access to justice and rule of law issues. Without much ado, and give context to my address, I will move and give you an overview on the access to justice issues which Mauritius faces currently. As we all know, access to justice is an indispensable correlate of the rule of law. This is principally firmly entrenched in the Constitution of Mauritius, as recognized by the highest court of the land, the Supreme Court. But you may also want to know that there lies an appeal from the Supreme Court of Mauritius to the Judicial Committee of the Privy Council that sits in London. So despite being a republic, and we've been a republic since 1992, Mauritius constitutionally kept the Judicial Committee of the Privy Council as its apex body to which all appeals finally go. But this is one of the features of having been a Commonwealth country, where we did not delink from an appeal process that goes to the Privy Council. Furthermore, access to justice is a very broad concept covering a range of issues such as affordable legal services, having a judgment delivered within reasonable time, which are all constitutional principles, impartial and non-discriminatory delivery of justice, and so on and so forth. It seems paradoxical that small states like Mauritius, with relatively smaller populations and seemingly fewer social challenges than bigger countries, should struggle with access to justice. Yet that struggle is very much real, as a more litigious mindset has set across all classes of ever-growing complex Mauritius society. The naughtiness of cases being dealt with across the tribunals and courts in Mauritius has also increased as Mauritius opened itself as an international financial hub or an international financial center. The Mauritian Parliament laudably churns out enactments. Parliament is sovereign in Mauritius under our constitution. However, there is constitutional supremacy because unconstitutional acts of Parliament can be struck down by the Supreme Court. That said, our enactments need to abide by international commitments, that is, our commitments vis-à-vis treaties, which Mauritius as a state has signed. Moreover, laws have also meant that more disputes of a very special nature before tribunals and courts, which may not have the level of specialization or even the necessary resources to deal with such cases. So increasingly, specialization has also contributed to an increase in number of fees across all areas of law. COVID-19 pandemic has not made things easier. The Mauritian legal system is still reeling from the effects of lockdowns, quarantine measures imposed following the emergence of COVID-19 pandemic in the country. This has resulted in the accumulation of pending cases awaiting determination before all the courts in Mauritius. The latest annual report of the judiciary highlights the total number of cases lodged at the Supreme Court increased by 6% from 2021 to 2022. In addition, a physical count of the total number of outstanding cases shows that 10,108 cases were not yet disposed at the end of year 2022, representing a rise of 2.4% over the figure of 2021. From that perspective, for a small state, these figures are, to say the least, quite worrying. Admittedly, significant efforts have been deployed to alleviate the access to justice problems in the country. The judiciary of Mauritius has its vision as being able, and I quote, to develop a justice system which is recognized as a national and international model of excellence, end quote. And two of these sector strategic goals of the judiciary are to promote a paperless judiciary with the implementation of new e-filing system and to enhance the management of information and communication technology like the e-judiciary. I must pause here to say that I was extremely impressed by the e-court system, which was displayed to us when we visited India last week, and the phase 1 to 4 of the e-court system in India. And this would be quite interesting to compare notes to get to that and be up to speed to that, I should say. So accordingly, specialized divisions in Mauritius with their own case management departments have been created. The judiciary has revamped both phases of the e-judiciary for the electronic filing of cases, such as before the commercial courts of the Supreme Court. Parties are encouraged to settle disputes using ADR, mediation division. Government has also undertaken reforms with respect to legal aid and is also consistently giving more visibility to Citizen Support Unit, CSU, to help people resolve their problems without necessarily having recourse to courts. Though significant strides to address the access to justice problems have been taken, it is generally recognized that more needs to be done as all countries strive to meet the SDG, the Sustainable Development Goal 16 of the UN, that is to promote just, peace, and inclusive societies. The question, therefore, is, can AI provide us with much needed panacea to small states like Mauritius for access to justice issues? The answer to this question, we should first try to understand what we mean when we talk about AI, and this is what I turn to next. As we all know from recent highly publicized conferences, AI is based on machine learning. Essentially, computers are designed to act intelligently through use of statistical algorithms to detect patterns, to enlarge data sets, and use same to predict future data and to perform other kinds of decision making under uncertainty, such as planning how to collect more data. Thus, like human intelligence, AI has the potential to reason abstractly, logically, and consistently, discover law and see through correlations, solve problems, discover rules in seemingly disordered material with existing knowledge, solve new tasks, adapt to flexibility, and adapt same to new situations, and learn independently without the need for direct complete instruction. So this is from an author, A.D. Dory Railing, who wrote recently an article, Courts and Artificial Intelligence. Now, artificial intelligence tools have demonstrated their usefulness and potential in many areas, not to say music, film scripts, but what was the use in the legal field? So as far as the legal field is concerned, AI tools have demonstrated a lot of promise. For instance, in 2014, a US company, Ross Intelligence, created AI-type questions and answer systems allowing lawyers to put questions on legal issues addressed by them. AI also reportedly reformed most law school graduates at the US bar exams. Logic's AI compared to the performance of experienced US corporate lawyers against the performance of AI to spot issues in non-disclosure agreements. While lawyers' achieved success of 85%, AI incredibly achieved a success rate of 94%. It has also been reported that lawyers took 92 minutes to complete a task, which AI only took, amazingly, 20 seconds to complete. So therefore, AI tools can be deployed in the legal field for many purposes and not limited to legal research, document production, and the review, predictive legal analysis, provision of legal advice, just to name a few. So how can AI help access to justice? First, AI has the potential to help litigants to bring and defend proceedings without assistance of legal representatives. As we know, costly legal services is a bar to access to justice. As it is worth noting that the Civil Court Structure Review final report in 2016 in the UK recommended the creation of online courts to attend to civil claims, which are small claims, so that would declutter the courts. As explained by Adrian Zuckerman, the computer would, based on the choice, and I quote, based on the choices and information entered by the claimant, produce a digital document approximating particulars of claim, which would be delivered electronically with any accompanying evidence to the defendant, who would then be able to use a similar process to generate the defense. End of quote. Second, AI tools can be used by courts to carry out case management tasks. This is where they're most useful, and to attend to routine and tedious time-consuming matters, leaving human judges to attend to cases of greater complexity. Third, AI tools could be used to enforce laws quickly and effectively, taking the burden off courts with respect to routine, for example, road traffic offenses. So it has been reported that in some large countries, developers are working with telecom providers to identify the pedestrians who break traffic laws, for example, crossing the road against a red light, and to send them a fine notification on their mobile phones as soon as they break such laws. There is no need for the bailiff. That is quite incredible, to say the least. These are only a few examples of how AI tools have the potential theoretically to access the access of justice gap, as I say, not only in small states, but in states of varying sizes and populations. However, the real question is whether AI will really help in bridging the access to justice problems. Will it create other access to justice problems for larger or smaller states like Mauritius? Now, in this, I would say it's not about being big or small. It's about a number of, well, incredibly cutting across issues. And one of those would be ethical issues ranging from accuracy, accountability, transparency, or bias. For instance, in cases where AI has been used to generate claims forms from impecunious individuals who assume responsibility where the claim has been wrongly drawn up, causing loss to the individual. In small states like Mauritius, where AI solution would presumably be implemented at the cost of the state, for impecunious individuals, would the state be willing to bear responsibility in relation to this system, given that developers of the system would be abroad and would be difficult for impecunious people to sue them in foreign states? Yet another challenge lies in the acceptance of the public, especially small states, which are only now getting up to speed with the computerization of their judicial systems. We are all very familiar with the adage that justice must not only be done, but must be seen to be done. This adage highlights the importance of how people perceive the justice system. One of the ways in which a court decision gets its legitimacy is through the reasons provided by the human judge to motivate his decision. However, when an algorithm is being used to take a decision, such requirements of transparency and accountability are not necessarily met. Will the ordinary man on the street be able to confidently state that justice is being done or seen to be done? In small states like Mauritius in particular, traditional methods of delivering justice are still being employed. For many in Mauritius, a physical court with a human judge equipped with court staff and a police officer is how justice should be delivered. This is what has traditionally been given, been there given in relation to justice systems for its acceptance and legitimacy. A move to AI tools to help judges with decisions to be taken may lead to a distrust in the institution using AI if that is not properly explained and people not properly sensitized. In other words, skepticism due to the lack of transparency or even understanding of AI may cause a doubt, may cast a doubt, in the competence of human judges to deliver justice. This poses challenges for access to justice, even in a larger states, the whole point being that people must have trust in the system. The idea has also been expressed that one of the eventual consequences of AI adjudication would be the disappearance of court as a physical entity, since the whole litigation process would have collapsed into one operation. In this respect, Professor Zuckerman, whom I mentioned earlier, writes that, and I quote, disembodiment of the court in serious matters, because the physical presence of a court where debates on issues of public interest take place has social value that transcends the immediate benefits of applying the law to the individual case. The right to open and visible justice, we should remember, is not merely a right of the parties to the dispute, but a public right, and that for some good reason. And that is extremely important because under the Mauritian Constitution, Section 10 protects what we call open justice. Now, the lack of technical expertise in AI in small states like Mauritius is another issue that may cause challenges as regard to access to justice. So far, we hear countries with relevant technical economic resources like the US, the UK, or even India taking the lead in the development of such technologies. It is therefore likely that most developers and companies providing such tools will come from foreign jurisdictions and not intraneous to Mauritius. As a result of the lack of local expertise, Mauritius will have to enter into contracts with private companies in order to implement and maintain AI solutions in the legal field, especially in the field of delivery of justice and legal aid. Next, Mauritius is a small country, quite atypical, but it also is a very large, diverse, multicultural nation. Different communities live, coexist peacefully alongside each other. And this is because of a conscious effort of all communities in Mauritius to do so and keep biases and prejudices out. However, as we know, AI tools develop their algorithms on the basis of a number of inputs which contain or may contain biases. Thus, with the implementation of AI tools in the legal field, it is hard to guarantee whether biases, whether conscious or unconscious, may be removed. Furthermore, it is conceivable that AI has the potential of exacerbating a gap between the rich and the poor, within businesses able to afford more efficient, reliable AI tools like the ChatGPT is now 2.0, 3.0, more sophisticated if it is subscribed to. And that can cause a gap between those who have and those who do not have. Such intervention of the state will probably be needed to bridge the access to justice gap through legislation and appropriate policies. So in conclusion, there are some but number of issues there which I have flagged out, and I wish to highlight from a perspective of a small nation like Mauritius. Of course, as is evident, many of these issues are cross-cutting, whether small state from societal, demographic, or financial factors, which also would interest larger countries. Nonetheless, although AI tools may help with access to justice, I am of the view that in the foreseeable future, human intelligence will still be relied upon to deliver justice. It may be that lawyers, especially in the corporate sector, will have recourse to legal AI tools to offer quicker and more efficient service to their clients. This will most certainly cause access to justice issues which the legislator or even the policymaker will need probably to address, especially given that it is hard to see how in the public sector AI tools will be implemented in the foreseeable future. So with these words, friends, colleagues, ladies and gentlemen, I thank you for your attention. I am indeed, again, extremely privileged to have been part of this platform this afternoon or this morning. It's already afternoon in Mauritius. And I will thank the Amity, the organizing team, the conference chairs, Professor Aditya Tomar and Professor Dr. Joshua Aston from Edith Cowan University, Australia, for giving me the opportunity to address you on the topic comparative technology law and emerging legal domains, which comparative in one sense, but cross-cutting along a number of jurisdictions, because these are seamless issues which would be important for all of us to address, whether from a small state or a large state. So thank you again very much for your attention. It was a pleasure to address you this afternoon. Thank you very much.
Thank you very much, sir. Thank you very much. Now I request to Sumitra to just introduce to the virtual dais to our honorable respected founder president, sir.
Yeah, thank you so much, Mr. Rajesh Ramlal, Deputy Solicitor General of Mauritius, for address. Let's have a round of applause for sir. Thank you. Well, ladies and gentlemen, all the eminent dignitaries over the days at the valedictory of ICCL 2024 conference, our honorable founder president, the founder president of Amity Education and Research Group and Amity Universities, Dr. Ashok K. Chauhan sir, is here with us. Dr. Ashok K. Chauhan sir is the founder president of the Amity Group of Institutions with 12 universities in India, with 16 campuses abroad, and with more than 28 schools and preschools. Over to Honorable Founder President, sir, for your address.
I would say to my students that this 2 days conference on comparative law is very close to my heart, because I want that more than 12,000 students studying law in my institutions, they become international lawyers, international advocates. And therefore, I was attending in between yesterday and today also the deliberations made by worthy speakers. At the moment, 5 laptops are in front of me, and I am surfing from one program to other program. But when I heard the voice of Rajesh Ramlal ji from Mauritius is Ramlal ji very close to my heart. I have been many, many times there, and when I established this campus, I have great expectations from Mauritius, and I heard your full speech, and I would request Bandyopadhyay ji to follow with him to make a request to Ramlal ji that during the next convocation at my campus in Mauritius, we want to bestow upon Ramlal ji, Rajesh Ramlal ji, the honor of honorary professorship. And I would request you to please accept it, because what I heard, I want you to also hold such lectures to my other students of law in other universities, because you have paved the way. What I am following, that they should have the international knowledge, international laws they should know, and I think you must be one of the best law firms in Mauritius. So when next time I come, or Asim Chauhan ji, who is looking after Mauritius, or Atul Chauhan ji, they will also meet you. I am greatly thankful to you, sir, for your deliberations. And Bandyopadhyay ji, please forward this link to all my law students in all universities. They should listen whenever they find time. Sumitra, you please facilitate it. Aditya Tomar ji, Shefali Raizada, and AP Bhanu, this lecture and other lectures, what has happened, should be listened by all my students at their time, whenever they find, but they should listen this. I also am very happy that after that, Venkata Mananji is speaking. Additional Solicitor General of India is a very, very responsible position. And in today's vibrant times, the role of additional Solicitor General or a soldier very, very, very challenging. And I once again, Bandyopadhyay ji, to you and all listeners, all my students, those students could not attend. I would request that they should listen all deliberations. Comparative law conference was so important. I've heard quite a lot, and I would say my congratulations to Bandyopadhyay ji, Shefali Kashyap, Aditya Tomar, Bhanu, and all faculty members, and above all my students. Sir, Rajesh ji, I'm so proud of my students. They are the selected students. Nowhere in the world is taught to them, in addition to the coursework, in addition to the laws, I make them a good human being to study the eyeball, the mood of the judge. You know it best. To plead good, we should read the mind of the judge. And I tell them, if judge is not understanding, you just say, sir, may I substantiate, and then take a 180-degree turn. Because if you understand the judge, mood of the judge, then you are bound to win. In last days, some online attending is allowed. I listen a lot, because I want to tell to my students which judge has the patience to hear long, which judge has the short patience to hear the long. And if my lawyers can command on this, I think they will be the best lawyers of the world, which are not taught in America, Switzerland, Mauritius. Mauritius maybe, because Mauritius very much this culture, but England, I've attended also in England. So when my students will have competence of understanding the mind of the judge, they cannot lose any case. Thank you very much to everybody, my dear student. I am proud of you. I'm proud of you. Thank you, sir.
Thank you, sir. Thank you very much.
Let's all have a round of applause for our Honorable Founder President, Dr. Ashok K. Chauhan, sir. Thank you so much, sir. Your presence always motivates us and inspires us to do more, achieve more, sir. And sir, today all the people here on this luminous dais have all become Amitians, because once an Amitian is always an Amitian. Thank you so much, Founder President, sir. Well, ladies and gentlemen, moving ahead in this platform on the of International Conference on Comparative Law Valedictory Ceremony, we have with us none other than our guest of honor, Mr. N. Venkatraman, Additional Solicitor General of India. But before I invite him, I remember B.R. Ambedkar, who said that justice is another name of liberty, equality, and fraternity. So let us now try to understand the Indian discourse right from our guest of honor, Mr. N. Venkatraman, Additional Solicitor General of India. Over to you, respected sir.
Namaste and happy greetings to people across the world who have joined this beautiful conference online. distinguished judges, additional solicitor generals, deputy solicitor generals, and others, and teaching faculty, and of course, dear students. See, instead of giving only the Indian perspective, let me use the 7-8 minutes available to me.
Sorry to interrupt you, sir. You got mute.
Yeah.
Am I audible now?
Yeah.
Yes,
Yeah,
yes.
Raj. Yes,
I
sir.
think I don't know. So okay, I'll just see whether. So the attempt will be to see how all of us can coalesce and harmonize our laws together in areas of common interest, more than giving only the Indian perspective. At least in these 8 minutes, we will focus on 3 areas which are of importance. One is the investment area, where, see, I think we are slowly, transformation is happening across the world where investments is not only from a capital exporting country to a developing nation. Lot of developing nations are doing business amongst themselves. And therefore, it is very paramount that we align our business laws, our investment laws, our commercial laws based on common interest and common concerns. The distinction, even today, when we decide on laws, we decide on adjudication, we decide on the course of how the law gets progressed. There will be, if you see the international jurisprudence of development of law, there is a distinction between a nation's law and a nation playing a role in the global space on legislation. It's a huge difference. They're not one and the same. International space is something to do more with diplomacy, more to do with power play, more to do with how each one can calibrate their relationships better. So when you scheme or draft a law, when the underlying objectives are these, then your calibration will have to be microscoped with the agenda of the interacting nations. So far, business laws, investment laws have been essentially bilateral. Some of the laws have been through treaties become multilateral. For example, you have the double taxation avoidance agreement. Many clauses across the world is one and the same. But there are several laws which is bilateral. So a conference of this nature, when people across the world are meeting to talk to each other, we should now find how amongst developing nations we can synergize a common business law efficacy. See, arbitration law or IBC law or any other company law, all this, if required, can be revisited by all of us who have common interest. Rather than to go only by some models, some models which, as I said, may be having an agenda of power play. So this is one area, especially when many of you whom we met last week had discussed about it, that we can just take it one step forward in this regard. This is as far as investment is concerned. Now, the second vertical is investigation. This is even more important amongst us. Whether it is a PMLA or whether it's an SFIO, we have several investigation agencies in economic laws in India. It could be income tax, it could be a GST, it could be a company law under the SFIO, it could be a money laundering, it could be a CBI, it could be a police. So there are cross-section of investigative agencies. So the common challenge all of us face, especially developing nations, is whether our territory is being used for laundering from our territory or into our territory, or whether our territory is used as a focal point for even a conduit or a round tripping or a circular trading. This is one area where we need to actually spend a lot of time and discuss and work together. Or else, what happens? The big distinction in investigation laws is this, the big disconnect, as I see, when we handle several cases across continents. We fight cases across nations in various courts and with various agencies we work with. Because we represent the Union of India as a law officer, I'm saying out of experience. The disconnect, the big disconnect is the speed at which the violator operates and the speed at which we try to connect with nations to seek help. There is a huge disconnect in terms of time, in terms of red tape, in terms of trying to harmonize as to what each one wants. Today, there are no cash transactions at all. Please understand, everything is done only through banks, most of them, or through cryptocurrencies. These are all the models which you try to handle. So, when you have these technology at your command, the speed at which money gets laundered from one territory, from your territory, or the speed at which a crime gets committed and the criminal moves fast across. It is universal principle, all of us know, because all of you should be handling judiciary in one way or the other. It's universal truth. Once money goes out of a country, once the criminal moves out of the country, bringing the criminal back or the money back is not an easy task. So, when it can move so quickly within hours, if we are going to spend months together in trying to see how we investigate together, see the huge disconnect in getting. So, when are we going to secure back? And when are we going to avoid our territory being used for these purposes? So, this is the second area of common interest among developing nations. And third is the adjudication process. See, there is a universal thinking, quite right also, that when it involves cross-border transactions, we cannot rely on one national court to advise or to adjudicate. So this is how international arbitrations came. How when different nations' law should never be a restriction. So they hived off some of their powers and gave it to international arbitration. But if you see what is happening in the last 15 years, progressively, there is a pattern emerging between developed nations and developing nations in this area. Again, it's a huge gap. So, what we are trying to underline in this talk is developing nations or fairly advanced developed nations. We can call, we have, India today is the fifth power player in the system, and our global space is being respected. Our decision making are being valued, and we have good amount of friends and relationship and sort of a trust we have built amongst developing nations. Developing nations are looking at India, and we are also looking at all of you with a lot of trust, with a lot of expectations. So the problems we have are common. So we should now join hands, not necessarily only politically. We should join hands in these, not necessarily only for trade relationship. We should join hands together in ensuring that we calibrate our legal systems, our laws with greater harmony, so that we can be a unified force in the global space. India is ready to take any initiative in this direction. There is a mandate from our Honorable Prime Minister, making it very clear. In fact, last week, it was he who came and inaugurated that conference for Attorney Generals and Solicitor Generals. It was the President who completed it. It was the Home Minister who gave the guest lecture. So we care for a long-term relationship with developing nations. And Prime Minister made it very clear. We are very particular about it's not enough if we grow economically, if we grow politically. We have to have the judicial space unified and harmonized. I'm so happy Amity has taken this great initiative in bringing all of us together for an exchange of this nature. May it become more and frequent. May all nations with aligned thoughts work together and draft legislations which benefit all of us mutually. Namaste. Thank you so much.
Thank you, sir. Thank you very much.
Thank you so much, Mr. N. Venkatraman. Let us all have a round of applause for sir. Wonderful presentation, sir. Wonderful discourse. And sir, it's a pleasure to tell you that after India's G20 presidency and furthering to envisioning Honorable Prime Minister's vision of promoting this universal sense of oneness blended in the theme of One Earth, One Family, and One Future, we are presenting to you the International Conference on Comparative Law 2024, and also that Amity University had participated in many of the G20 activities and S20 activities. Well, everyone, in the presence of our Honorable Founder President, Dr. Ashok K. Chauhan, sir, also the Patron-in-Chief of the International Conference on Comparative Law 2024, it's our pleasure and delight to present the citation of honor to all the eminent dignitaries on this luminous dais of the valedictory ceremony of ICCL 2024 conference. And now to present the citations, I'll request Dr. Jane Iyer Matthew. Yes, sir.
My great appreciation to our additional Solicitor General Venkataramanji. We should invite him 2-3 times again. My appreciation, Aditya Tomar, to Venkataramanji, and we should invite him 2-3 times again for his another lectures.
Yes, sir.
So very useful for my students, for me, for everybody. So Venkataramanji, I'm grateful for your coming. Thank you. Thank you.
So happy,
Thank you,
sir.
Thank you so much, Founder President, sir. And Mr. N. Venkatraman, sir, I'll get in touch with you as directed by Founder President, sir, and I'll take dates from you for the lectures. In the presence of Honorable Founder President, let's proceed to present the citation of honor to all the eminent dignitaries of the days. I'll request Dr. Jane Iyer Matthew, co-convener of this conference, to read the citation. Dr. Jane. I'll request Mr. Rupendra, convener of this conference, to share the citations.
The citation reads as follows. This citation is presented to Mr. N. Venkatraman in the valedictory section of the International Conference on Comparative Law on Saturday, the 10th day of February 2024. Mr. Venkatraman, a noted jurist in taxation and commercial law, is the Additional Solicitor General of India. Mr. Venkatraman, a proficient litigator and true professional who leaves no stone unturned in pursuing the cause of justice. We are highly obliged to Mr. Venkatraman for his presence with us and for delivering a thought-provoking address. We hereby recognize the contribution made by Mr. Venkatraman and express our deepest sense of gratitude to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Thank you so much.
I'll request Mr. N. Venkatraman, Additional Solicitor General of India, to accept the citation.
Yes, I virtually and really accept the citation with deep honor. Thank you so much, please.
Thank you so much, sir.
This citation is presented to Honorable Ms. Najat Abu Chakra in the valedictory session of the International Conference on Comparative Law on Saturday, the 10th day of February 2024. Ms. Chakra, an investigating judge at the Military Court of Lebanon. A robust personality, Honorable Judge is always in the pursuit to deliver justice. We are thankful to Justice Chakra for investing her valuable time and enlightening us with her words of wisdom. We hereby recognize the contribution made by Justice Chakra and extend our sincere thanks to her. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia.
I'll now request Honorable Ms. Najat Abu Chakra, Investigative Judge, Military Court, Beirut, Lebanon, to accept the citation.
Thank you so much, Dr. Zink. Thank you so much for Amity Law School. I'm really, again, so proud and so happy to be with you for the third year. And hopefully we will continue our contribution for the next coming years.
This citation is presented to Mr. Rajesh Ramlal in the valedictory session of the International Conference on Comparative Law on Saturday, the 10th day of February, 2024. Mr. Ramlal is a legal luminary to reckon and has vast experience in areas of commercial law and taxation law. Mr. Ramlal's in-depth knowledge on tax laws is commendable. We are deeply indebted to Mr. Ramlal for sparing his valuable time and enlightening us with his words of wisdom. We hereby recognize the contribution made by Mr. Ramlal and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia.
I'll now request Guest of Honor, Mr. Rajesh Ramlal, SC, Deputy Solicitor General of Mauritius, to accept the citation.
Thank you very much. I'm deeply touched, as I mentioned, and it's a privilege, it's been an honor to be with you this afternoon. Of course, I'll continue the work, as Professor Chauhan just mentioned, not only with Amity Noida, but also Amity in Mauritius. Thank you.
Thank you so much.
Thank you, sir.
This citation is presented to Mr. Alfred Tua Yeboah in the valedictory session of the International Conference on Comparative Law on Saturday, the 10th day of February, 2024. Mr. Alfred is a litigant and a politician holding the post of Deputy Attorney General and Minister for Justice, Ghana. Mr. Alfred combines both professional service and community service, thereby giving back to the society. We are thankful to Mr. Alfred for sparing his valuable time and sharing with us his thoughtful insight. We hereby recognize the contribution made by Mr. Alfred and extend our heartfelt gratitude to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia.
I'll now request Guest of Honor, Mr. Alfred Tua Yeboah, Deputy Attorney General and Minister for Justice, Ghana, to accept the citation.
I'm humbled by this citation. I think this one is rather a challenge to me to do more in my duties as a Deputy Attorney General, and also as a private legal practitioner when I leave office as a Deputy Attorney General. Once again, I'm grateful to you. Thank you very much.
Thank you.
Thank you.
This citation is presented to Honorable Shadrach J. Mose in the valedictory session of the International Conference on Comparative Law on Saturday, the 10th day of February, 2024. Honorable Mr. Mose is the Solicitor General of the Republic of Kenya, a dynamic personality with profuse knowledge of around 30 years in litigation. Honorable Mr. Mose is a litigant par excellence. We are deeply indebted to Honorable Mr. Mose for sparing his valuable time and enlightening us with his words of wisdom. We hereby recognize the contribution made by Honorable Mr. Mose and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia.
I'll now request Guest of Honor, Honorable Shadrach J. Mose, Solicitor General of Republic of Kenya, to accept the citation.
I am extremely humbled and delighted by the experiences that are shared across the board. This is my first appearance, and I'm looking forward to much more interaction, to much more sharing, to much more, making the world a better place for all of us to live in, and for all of us to actually ensure that society is better than we found it. I accept the citation.
Thank you, everyone. For it is said that once an Amitian is always an Amitian, and wherever you go, your name with Amity will remain forever. Thank you, everybody. Now it's time to declare the results of the Best Paper Award. And I'll now request to do the honors Dr. Joshua N. Aston, Associate Dean and Conference Co-Chair of the School of Business and Law, Edith Cowan University, Western Australia, together with Mr. Rupendra Singh, Convener, ICCL 2024 Conference, to declare the results of the Best Paper Award. Over to you, Mr. Rupendra.
Thank you very much, Dr. Sumitra. So the most awaited in this conference, we got around 380 abstracts, and we have selected 230 presentations. So we start with our best paper technical session wise. In order to accommodate these 230 papers, we have divided them in the 20 technical sessions, and we are giving the best paper awards technical session wise. So best paper technical session 1 goes to Mr. Jayesh Rathore and Dr. Bharat Rathore. The title of their work was The Comparative Analysis of Intellectual Property Rights in NFTs and the Metaverse, Unraveling Legal Dimensions in a Digital Realm. The second, in the technical session 2, the best paper goes to Ms. Akanksha Sharma and Dr. Rekha Verma, and the title of the work is Comparative Analysis of Judicial Interventions Addressing Mentally Ill Offenders in Modern Legal Systems. In the technical session 3, the best paper award goes to Dr. Thangsup Toming and Ms. Devapriti Sharma, and the title of their work is Contesting Claims Against Polygamy and the Constitutional Mandate. Best paper for technical session 4 goes to Dr. Monica Chaudhary, and the title of her work is The Process of Appointment of Election Commissioners, a Comparative Study of the Constitutional Scheme in India and Pakistan. In the technical session 5, the best paper goes to Mr. Siddharth Fuller and Mr. Yuvraj Yadav, and the title of their work is Affirmative Action in Education Institutions in India and USA, a Comparative Study. In the technical session 6, the best paper award goes to Dr. Shivam. The title of the work is Comparative Constitutionalism and Global South. In technical session 7, the best paper award goes to Ms. Hiteshi Agarwal. The title of the work is Comparative Analysis of Rule of Law in India and Germany. And there's entire, and Dr. Kriti Pashar also get a best papers award there. And the title of the work is Positive Affirmation Through Horizontal Application of Fundamental Right to Education, a Comparative Study of India and South Africa. In technical session 8, Dr. Abhishek Sharma, Padmavan, and Mr. Pawan V, they got the Best Papers Award, and the title of their work is A Comparative Exploration of the Jurisprudential Development of Separation of Power in India and Australia. In the technical session 9, it is Ms. Rahi Ajabe Alhat got the Best Papers Awards, and the title of the work is Forensic Evolution and Criminal Justice Practices, a Cross-Cultural Examination of Laws in India vis-a-vis Australia. In tech session 10, the Best Paper Award goes to Ms. Apurva Chaudhary, and the title of the work is Legalizing Same-Sex Marriage, a Comparative Analysis of Legislative Approaches and Societal Impacts. In the tech session 11, the Best Paper goes to Mithali Gupta and Ms. Tivra Sinha, and the title of the work is Cross-Border Perspectives of Female Genital Mutilation Laws in India and I'm sorry, I believe there is some error in the title of the work. So there is a comparative analysis of the female genital mutilation. Technical session 12, Best Paper goes to Mr. Mohammad Zulfikar Ali and Prafulla Pierce. The title of their work is Difference Between the Theory and Practice Bangladesh and India's implementation, challenges of the ILO safety and the health shipbreaking guidelines. Technical session 13, the best paper goes to Mr. Ajitesh Kunda. The title of the work is Comparative Analysis of Institution of Ombudsman in India and Sweden, focusing on the reasons for failure in India. Technical session 14, the best paper goes to Ms. Dhanalakshmi. The title of the work is Comparative Analysis of Insider Trading in Capital Markets, Study in India and United States. Technical session 15, the best paper goes to Mr. Sagar and Dr. Saltanat Sherwani, and the title of the work is Mandatory Mediation, a Comparative Approach to Understand the Benefits and Pitfalls. Text session 16, the best paper award goes to Dr. Tanzim Afroz and Ms. Preeti Kana Sikdar, and the third author over there, the Mustafa Reza Noor, and the work is the Comparative Study of Climate Development Integration in National Development Policies, Insight from Bangladesh. There's a tie, Nadia Rahman, and Ms. Nabia Farheen has also got the best paper awards. And the title of the work is To the Stars and Beyond, Comparative Legal Analysis of Space Governance Between the Bangladesh and India. Text session 17, the best paper goes to Mr. Helen P. Aziu and Abhishek Chakrabarti, and the title of the work is a comparative analysis of the interaction of the ethics and biotechnology patent law of India and the European Union. Text session 18, the best paper goes to Ms. Chavi Dhawan, and the title of the work is From Ancestral Wisdom to Legal Fortress, Traditional Knowledge Preservation Through Intellectual Property Frameworks. Text session 19, the best paper goes to Ms. Himka Ghoshal, title IP Enforcement and the Fast Fashion Industry, a Critical Analysis. In the technical session 20, the best paper goes to Dr. Deepak Sharma and Mr. Vidit, and the title of the work is Bridging the Gap, Can Technology Enhance Rehabilitation, a comparative study of GPS monitoring for pre-trial release in India and United States. So congratulations to all the best papers awardees. We certainly going to accommodate these best papers in our research books or as well as in the journals. So thank you very much. So we in this 20 best papers, we map all our themes starting from the constitution, business, IP, tech, family, and the criminal law. So congratulations once again.
Thank you, Rupendra sir, for presenting the best paper awards. Also, Dr. Joshua Aston is here. I would like to take some inputs from Dr. Joshua Aston as the best paper awards were presented here. Dr. Joshua Aston.
I'm extremely delighted to see the kind of work that has gone into by the. Can you hear me?
Yes, sir. You are audible.
Yes, I'm extremely delighted to see the work that has gone into making this conference. Those 20 technical sessions, the quality of abstracts that we received and the papers that were presented were really very good, very high class. Congratulations to all the ones who have made it and to all those who attempted to participate in the conference and will probably, take a lot of lessons from this conference and go back and work on their papers and do well in their space.
Yeah, thank you, Dr. Joshua, for those inputs. Well, in the same breath, I'll request Dr. Joshua and Aston to also present the conference report. Over to you, Dr. Joshua, once again.
Many thanks, Dr. Sumitra Singh. Good evening to distinguished guests, members of the Amity family, ladies and gentlemen, and of course, my dear students. I am really privileged to have been entrusted with the task of presenting the conference report, and I'm genuinely delighted to fulfill this responsibility. In 2019, our journey began with the inaugural of the International Conference on Comparative Law, and now we proudly celebrate the 5th edition. Amity Law School, Noida, in collaboration with the School of Business and Law, Edith Cowan University, Western Australia, has co-hosted this 2-day conference. The primary focus of our conference revolves around comparative law. With Droit Compare as the guiding principle, we have delved into the interconnectedness of individuals, businesses, and governments, emphasizing the importance of international and comparative legal studies. Now, this conference encompasses various sub-themes such as comparative constitutional law, comparative criminal law, comparative media law, intellectual property rights and technology laws, comparative business laws, and comparative family law. Apart from the inaugural and valedictory sessions, we organized 4 keynote sessions, and we were pleased to receive 370 plus abstracts from over of which 230 papers were selected for presentation across 20 technical sessions, and these were conducted in the hybrid mode spanning 20 different sessions. The conference also witnessed the signing of MOU by Amity Law School, Noida. And I would like to inform that the keynote sessions were very thought-provoking and insightful. To give you a glimpse, some of these were insight on methodologies to be adopted for the study of comparative law, evolution of constitutionalism across the globe, significance of reservation and intent of the framers of the Constitution, and how the changing times there needs to be change in our perspective, emergence of new Constitution and need for staying in line with the core element of Constitution and its basic structure, conclusiveness in arbitral awards and how it paves way for arbitration and the need for promoting public policy, procedural fairness for the trial, justice for the under trials and the juveniles, emergence of new technologies like AI, NFTs, and legal challenges posed by them, changing paradigm of IPR and policy across the globe, and finally, startups, investment, arbitration, CSR, and cross-border mergers were the major issues discussed under this domain of comparative business law. So the development of comparative legal jurisprudence has been greatly aided by this conference, I would say. And we plan to use the lessons learned to forge future partnerships in both studying as well as teaching. Now, we sincerely hope that everyone who has attended this conference has gained something out of it. And looking ahead, we remain committed to advancing the discourse on comparative law and fostering greater collaboration across borders to address the complex legal challenges of our time. That concludes the report of the 2-day conference. And before I finally leave, I want to say how delightful I am, and we all are, at Edith Cowan University on behalf of the Council of Australian Law Deans to work with Amity Law School, Noida. I commend the leadership at Amity University for nurturing and facilitating this collaboration. And I also look forward to working with you again in co-hosting the next edition of this conference in 2025. Thank you for your indulgence.
Thank you so much, Dr. Joshua. That fills us with more enthusiasm now. And shortly, we will declare the dates for the next year's conference. Thank you for presenting the report very briefly. Well, ladies and gentlemen, boys and girls, it's time that we also talk about releasing some of our publications in this valedictory session of ICCL 2024 in the presence of all the eminent dignitaries over the luminous days. Here is the first release during the valedictory ceremony. We release our first publication during the valedictory ceremony. This is the Handbook on Comparative IPR Law, Technology Law, and Emerging Legal Domains, being edited by Professor Dr. Aditya Tomar, Dr. Joshua Aston, Ms. Mini Srivastava, and Mr. Rupendra Singh. Many congratulations for the release of this book. We would now release another book in the presence of all the eminent dignitaries of the days. This is the book on comparative legal contours of IPR and technology, being edited by Dr. Aditya Tomar, Dr. Joshua Aston, Ms. Mini Srivastava, and Mr. Rupendra Singh. Many congratulations, editors. We would now release the third book, and this is the Handbook on Comparative Criminal Law, being edited by Dr. Aditya Tomar, Dr. Jane Iyer Matthew, and Dr. Abhinav Tomar. Many congratulations, editors, and everyone who's contributed to the book. We would now go ahead with releasing other books. This is the Handbook on Comparative Constitutional Law, being edited by Professor Dr. Aditya Tomar, Dr. Priyanka Ghai. Many congratulations, editors. And the book is brought up by Bharati Publications, New Delhi. We would now release another book, which is the Handbook on Comparative Business Law, being edited by Professor Dr. Aditya Tomar, Dr. Joshua Aston, Dr. Abhinav Tomar, and Mr. Rupendra Singh. Many congratulations, editors, at this ICCL 2024 valedictory ceremony. We have another book, which is Comparative Law, Unraveling Global Legal Systems, being edited by Dr. Joshua N. Aston, Professor Dr. Aditya Tomar and Mr. Rupendra Singh, and this is a Springer publication. Many congratulations, editors of all the books, and I invite everybody who's joined this conference to keep sending in their papers to the organizing committee of ICCL. And you have seen that we've released so many books, around 6 books are released, and it's a pleasure and delight that we connect with academia and also with the legal systems across the borders. Now, as we come towards the end of this session, I feel really, really nostalgic to leave this portal and the panel. However, there is one more thing which is remaining, but that I'll tell you after the vote of thanks by Professor Dr. A.P. Bhanu, Additional Director and Joint HOI, Amity Law School, Noida. Over to you, Dr. Bhanu, sir.
Thank you, Sumitra Singh. Thank you very much. As we always know and see that the valedictory session is a mark of, the success. And success is reflected always in the happiness and the pleasure. In this session of today, I have seen at least 4 points. The one point is that to declare the success, we have seen the presence of Honorable Founder President. He himself has come and he himself has said that this comparative law conference is very, very important. Second point is that the best paper award, some technical, the papers award. The next success mark, which I have seen that Dr. Joshua himself shown a very positive mark, shown that we are going not only up to this organizing the this conference, but we are going beyond this. We are going to have a great relation with MIT and Edith Codman University. So for that, Dr. Joshua ji, we are so much thankful to you. Today, I have seen that in the connection with this comparative law discourse, in this concluding ceremony, all the honorable valedictory speakers addressed the utility of the comparative law approach. I have seen that Honorable Sadrog ji, who is a Solicitor General of Republic of Kenya, from different angles, he elaborated the constitution of the country and established that the constitution of that country is also reflected the outcome of the comparative law approach. So, sir, for giving your valuable words and insight of the constitution of your country, we are so much thankful to you. You have given us a time, you have spared a time. Sir, we are much, much thankful to you. Now coming to Ghana, where Mr. Alford had precisely given, the very briefly, the whole outline of the Constitution. I can recall my friend Pradeep Sharma, who is in the University of Ghana, he is a professor there. He used to tell me about the basic principles of the Constitution of Ghana. So when I have heard today, Mr. Alfred, I found very amazing, very pleasurable moments. Sir, you have given us a time and come. We are thankful to you, sir. Now, coming to ma'am, Miss Najat Abu, she has also given a different perspective through human rights discourse. She has also deliberated upon the utility of comparative approach. We are thankful to you, ma'am. Now coming to Mr. Rajesh Ramlal ji, who is from Mauritius, he has also given his own approach towards the support of AI to support to, the assist, the e-courts, e-filing, and support of the other things. We are thankful to you, sir, for giving such an insight so that the other country and the research scholars from other country can also act upon that and find out the best out of what you have said. We are thankful to you. Now coming to our Honorable Mr. N. Venkataramanji, who has precisely emphasized upon the point that is the common concern, the common problems, whether they are the IBC law problem, arbitration law problem, PMLA law problem, investigative problems. He has emphasized upon 2 points that we have the common problem. So why not we go for solving these kind of the problems by studying all the systems, the law, the intricacy within the system through the mode of comparative law. Sir, precisely, you have given us such a vital point. We have received and we will certainly work upon. Thank you so much, sir. Thank you very much. The point does not end here, because our conference, this was a 5th conference in collaboration with Dr. Joshua Ji. It started in 2019. We are so happy to see, and it is continue. And the inaugural session was started on 9th of this month. And you can see that in inaugural session, there were great legal luminaries. There were great leaders. Great luminaries like Justice Deepak Mishra ji, former CJI, Rituraj Avasthi, Justice, Professor Manoj Sinha ji, Vice Chancellor, they were there. They also, I heard them very carefully. They had expressed their view on widely taking up the comparative approach while you are studying not only the law, but applying the law on the problems. Therefore, I can say, in the context, this discourse on comparative law has become, specifically in a modern era, this has become so important. I cannot say that this was not available earlier to this, the introduction of AI or new technology. No, it was there. If I cite within 30 seconds one example of our constitution, then I can say then that our constitution, when it was in making, the UDHR was also finalized. And part 3rd of Indian constitution was discussed for 38 days in constituent assemblies. 38 days. So that it was discussed so that the fundamental rights which were intended to bring in part 3rd of Indian Constitution could touch, could feel the finality of UDHR and other practices which were there, in national practices. So comparative law utility is not a new, it's a since very long time. So for this discourse, we are here, and I'm so much thankful to all of you. And I'm also thankful to the speakers, those who have come from different parts of the world. During technical sessions, several issues were deliberated, debated in different field of the of this law. We are thankful to them. We cannot just ignore their contributions. Now, Dr. Joshua Ji, again, I'm coming to you. Dr. Joshua Ji, Associate Dean, School of Business, Edith Coben University, Western Australia, who is an integral part of international conference, I can understand, sir, without your collaboration, this great conference would not be possible. If somebody say it was possible or it is possible, I would say it may be possible, but not in comparative perspective discourse. So this is the great contribution from your side, which I have recognized, which I am acknowledging. For that, I'm appreciating to you, and I'm thankful to you for your kind gesture, sir. My warm gratitude is due towards our Honorable Founder President and Honorable Chancellor, sir, who always wish to see us growing. We are really great. We are really grateful to them for shaping this MET organization as MET Universe with more than 16 global campuses. I want to convey my sincere thanks to Honorable BC ma'am. She was there in an inaugural session. I heard her, but now she's today, I think she's busy, therefore she could not come. We are thankful to ma'am, very much thankful. Our beloved chairman, sir, who showed some kind of the urgency. He could not stay, but we cannot ignore his constant guidance, support, and every type of the problem solving method. We are thankful to him also. Now, 2 points, 2 persons are very much important. One is chair and other one is co-chair. Both chair and co-chairs deserve a big congratulations for organizing such a big international conference on comparative law. Now, we cannot also ignore organizers. Organizers, not only the faculty members, but organizers include our beloved students too. I am, on behalf of MET Law School, extend my sincere thanks to them also. The conference has been organized in a hybrid form, and you can understand this is not possible without the IT support of the MET. Therefore, we are grateful to IT colleagues for extending their constant support to give their support for organizing this international conference. It would be a mistake on my part if I forget to extend my thanks to all our administrative officers, staff members at MET who always extend their support. We are thankful to them also. Last but not least, I extend my heartfelt thanks to my colleagues and all those who are directly or indirectly involved in organizing this program. But still, there is a big thanks which is still remaining in my mind, is that it is only one. One is Dr. Sumitra, who always, operate the program. She deserves, from my side, a big thanks. Thank you, Dr. Sumitra ji. Thank you very much. So thanks to one and all. Thank you very much.
Thank you so much, Professor Dr. A.P. Bhanu, Joint HOI, Amity Law School, Noida, for presenting the vote of thanks. Ladies and gentlemen, boys and girls, as India has become more decisive, inclusive, ambitious, and a nation that is moving ahead of so many nations across the globe, we believe in one thing, and that is global brotherhood and camaraderie. As Honorable Shadrach Moose also said, that we are there for each other. That gives us strength and hope. And with that, let's together create a hopeful, healing, and a harmonious world. And International Conference on Comparative Law is one such platform conceived by Professor Dr. Aditya Tomar and Dr. Joshua Aston, together with the convener, Dr. Rupendra Singh and Dr. Jane Iyer Matthew. Many thanks for giving us this platform of ICCL. And I said that I feel very nostalgic as I leave this platform, but we have tried to give a face to this nostalgia in the form of a creative. So presenting to you this teaser as we leave this platform with a lot of nostalgia. A beautiful teaser. It will always keep reminding us about the beautiful memories that we made, the new friendships that we made, and the discourses we attended to. And lot of learnings that we got from this conference. We formally have to end this conference now with this valedictory ceremony. But if there is anything that anybody would like to talk about, it's now over to you, Aditya Tomar sir. If there's anything that you would like to say.
I don't want to take much of the time. I just want to pay my regards to all the esteemed guests, especially Rajesh sir, Shadok sir, Nazat ma'am. Thank you very much. You just spared a lots of time to just interact with the students and the participants. Thank you very much, sir. Thank you.
So now everybody, with the permission of conference chair, Dr. Aditya Tomar sir and Dr. Joshua Aston and all the guests, can we now end this session?
Okay, Dr. Sumitra, thank you.
Thank you, everybody.
Thank you,
On
everyone.
behalf of our Honorable Founder President, goodbye and God bless everybody. Bye-bye and take care. Till we meet again.
Thank
Bye.
you. Thank you. Thank you. Thank you.
Thank you. Bye, everyone. Take care.
Bye-bye.
Thank you. Bye.
Okay.
Bye,
Bye-bye.
Najat ma'am.
Ma'am, can I end the session?
Yes, Maqsood sir, please end the session. Thank you so much.